Welcome to another episode of Unlock. I'm your host, Daryl L. Davis. Welcome to Unlock. Uh, we're here for another episode. But before we start, make sure that you like, subscribe, and share the contents of this video. We on location today in a town called Venus, Texas. We're going to be interviewing a former TDCJ inmate, which is Gregory Moore. But before we get started with that, we want to do a TDCJ update for this week's edition of Unlock with Daryl L. Davis. This week, we're dealing with heat-related issues within inside the TDCJ. Temperatures have already reached over 110 degrees, and today is just July the 4th. So I guess they would say Happy Independence Day. But ain't nothing happy about it for me. But nevertheless, we're just going to roll on with this show and get the best out of it that we can. Dealing with the heat that's in TDCJ, inmates have already started to suffer heat-related illnesses. Some have been hospitalized since June the 15th. We'll be bringing you more updates on that as we move into the summer. TDCJ is still stalling its feet on putting air conditioning inside the prison system, which was something that should have went into effect some time ago. Dealing with the issues of overheating amongst inmates in the Texas Department of Criminal Justice. And with that said, that's our update on this week inside TDCJ. Remember, if you have loved ones that's inside that prison system, whether it's the state of Texas or any other facility that's inside the Texas Department of Corrections or any other corrections throughout the United States of America, right now is the time that you can address whatever it is they're going through heat-related wise. As we said, we're on location today and we have activity going on. We at the home of Gregory Moore, who invited us in to do an episode of Unlock. And at this time, we will welcome our guest, Mr. Moore, in to be with us. Welcome in. How you doing?
How you doing, Daryl?
Everything good?
Good.
All right, good to see you, man.
Good to see you.
Yeah, it's been a
Amen.
while.
Amen.
Last time we seen you when? June 2015.
Yeah, something like around that. That was at the Michael unit.
Michael Unit. May parole.
Yeah, May pull off the East Ham unit.
Yeah.
I got transferred from Michael to East Ham.
Yeah, I made parole on Michael, 2015. June 2015, I probably left that Thursday because I remember spending the nights over at the Walls unit, and I got out the next day, which was June the 5th of it was a Friday, 2015. Yeah.
Yeah, so I left the Michael sometime in 2018, and got sent to the East Ham unit, which is now the Wainwright unit.
Okay.
Time naming the units.
Okay. How did we meet on the Michael unit?
Well, actually, we met first time in the law library.
Mm-hmm.
Joe had just arrived, and he was working on some civil litigation that he was working on. So I got a little overview, but because of the housing, I didn't get to see him much.
Mm-hmm.
And it was through Mr. Hall when the district court had dismissed the suit that Mr. Hall had said that I think I was waiting in the infirmary cage to go see the nurse that day, and Mr. Hall said if anybody can help you get this case back in the court, Gregory can. So he came over to the cage and we talked, and we set up a legal visit in the law library, and then we took off before the Fifth Circuit, and then we hit a home run.
No, that's not how it happened. No, I had never filed a case.
You had at that time out there, hadn't you?
No, we hadn't filed a case yet.
Not when I first met you yet.
No, we filed a case together
Yeah.
in 2007. You remember? Because I had just made it over to the unit from being attacked by gang members.
Yeah.
Right? I didn't have my spirits here until after I got to the Michael unit.
That was the time we discussed before, really.
And I got to the Michael unit in like May of 2006.
So much ago, yeah.
And when did you get there? Because you got there before I did.
I got to my community in 2003.
2003. So you was already on there 3 years before I got there.
Or 2001, I think it was when I got to my community.
On the Michael unit? coming from Beto.
Kind of meeting.
Okay. And you had a similar altercation that I had.
Yeah, similar.
Yeah. I don't know if yours was gang related or yours just isolated.
Yeah, it's kind of a group effort that was going on.
Yeah, but it wasn't gang related.
No, not gang related.
Mine was gang related, right?
Yeah.
It's a difference. So what we're saying that when you in prison, people, you have to always be mindful because you can be attacked by gang members or non-gang members who have formed a clique against you. And this is what was formed against you, right?
Yeah.
A clique of men felt some kind of way about you and lashed out, right? But with me, it was actually gang that felt some kind of way about me that lashed out. So in prison, you always have to be looking for the unknown.
And also, you got certain units to where there's just a lot of stuff going on in the concrete jungle. You got certain units where it's real laid back. Like for instance, the East Ham unit, the older East Ham unit right there was real bad. That's where Clyde went out and shot up the officers and broke some people out.
Yeah, Clyde Burr.
But once they built the new facility, at one time the East Ham unit was called the House of Pain because it was real bad. But when I arrived there, and Michael West, our field minister, he told me that you're going to a good unit. And at the time, the House of Pain got turned into a House of Prayer.
Mm-hmm.
The Therapine program was set up on East Ham, and it had probably one of the best chapel programs we got in the whole state.
And what year was that?
Well, I got there in around about 2018.
Oh, yeah.
And I left somewhere around 2020. Spent about 2.5 years at the East Ham unit.
Well, most definitely had been transformed at that time.
Yeah, been majorly transformed.
Yeah, because when you start talking about coming through the 70s and the 80s,
those were rough units.
is when you was talking about, because when I was there in 97, it was notorious. But when they started building those new structure units, like they started building the Michael, that was orchestrated in 1990, and that was structured on a different kind of.
The Michael was the first prototype.
Yeah, of that style.
Yeah, that style.
And that style unit was designed to handle aggressive men, animals, right? And they wanted taking them from the units like the Darringtons and the East Ham and the Cofields and start throwing them on units like that.
In fact, on Michael unit, it started happening when you made parole. Between around about 2015 2018, as you know, our 7 building used to be a PC type building.
It was.
So they phased that out, and that Telford had a lot of fools on Telford.
Mm-hmm.
So they started shipping a lot of the bad actors off Telford. And the Michael unit, the last I'd heard was that 7 building was medium custody and 8 building was all closed custody. And when I worked for the Major Utility Squad, dealing with them guys down there was a mess. I mean, they want to throw piss and water on you, and you ain't doing nothing to them.
Well, I wonder what they did with the PC.
Well, they shipped them off to other units.
Okay.
They were doing that before I left.
Well, you know, at one time, Michael was ranked in the top 15 of the most dangerous units in the state of Texas, right? That Turl unit, which Nancy Polonsky unit, was number 2 in the whole United States of America as being the most deadliest unit in the United States. Then you had the Robertson unit, the All Red unit. Those 3 was in the top 10.
And see, another thing is S.O. Woods Jr. used to be our chief of classification for many years.
Mm-hmm.
But when he retired and left, the chief of classification became a revolving door. And under S.O. Woods Jr., that, say for instance, you were a first-time offender, you got a little 5 or 10 year sentence. Well, like when I got sent to, you get sent something like what they call the old Ramsey 3. Mm-hmm. And those are laid back units, don't even have a medium custody. It's all dorms. There ain't really never nothing going on. It's wide open. And you don't got really nothing, no gang activity going on. It's like a paradise doing time. But now they may take somebody with a first time offender 5 year sentence and throw him on the Beto unit right down on the wing, just gang infested.
That's what they do. That's what they do. That Ramsey 3 unit is now the Turl unit. Yeah, it took the name Charles T. Turl from that unit in Livingston, Texas, and moved it to Ramsey 3 down in Rocheron, and renamed that Turl unit the Allen B. Polunsky unit. That unit housed death row. And I was on that unit. That's the unit that I was on when I was attacked by gang members in 2006. Correctional officer paid $3,000 to have me killed behind 2 ice cream sandwiches and 2 sodas that I didn't know anything about. And when I was finally put in PhD, which is pre-hearing detention, and transferred to another unit, is when I met you and we began to litigate the case. At that time, it might have been you that had told me that Judge Guthrie was coming on the unit to hold spirits hearings. You remember that? And
which I never seen it. It's always done with video conferencing.
Later, because that was inappropriate. She couldn't come on that unit to conduct spirits hearings, right? How could she be biased? And the administration was taking care of her, seeing her in the ODR.
That's a reflect a lot of her rulings to that effect.
And a lot of inmates got punished for that because their suits got dismissed.
And for any of the fellows that may be watching podcasts or our family members, we've got loved ones, that my advice is always when you file any kind of civil claim, if you file a civil claim in the U.S. District Court, you're going to usually have a spirits hearing. And your magistrate judges like to lullaby you. They show sympathy for your litigation. They act like they're all in your corner, and they want to get you to consent for them to handle your case. And you also will be notified by the clerk's office. My experience and my advice is never consent for the magistrate judge to handle your case. Because a lot of these magistrate judges could have an incentive to show favoritism towards the prison officials. And what does it allows you that if the magistrate does rule against you, you're allowed to do an objection before the United States District Judge. And with them judges, they got to be careful about their conduct because they're under more scrutiny than the magistrates are. So, but my suggestion is don't never consent for a magistrate judge to handle your case.
Well, you know, we got dismissed twice by a magistrate judge, right? Magistrate Judy Guthrie.
Same with me on my suit.
Eastern District. Right.
He was recommended, but and actually, it come to a point that United States District Judge Leonard Davis, he felt so strongly that I had merit to my suit that without giving any kind of reason, because basically I proved that Judge Guthrie was having ex parte communications with Dismary, trying to get Dismary and put me under pressure to consign for the consent so she could dismiss my lawsuit. But I refused. I got called to the Dismary office and threatened. And I refused. I said, do what you're going to do. I ain't consenting for her to handle my case.
Well, you know, that seemed to be a track record of Magistrate Guthrie because she appointed me an attorney out of Nacogdoches. I believe his name was Guillory.
Yeah.
You remember? And when she appointed him, she was holding ex parte communication with him outside of my presence, right? And we was able to get him off the case. By filing to her boss, which was out of Beaumont, Ron Clark.
That's what Ron Clark did for you. Leonard Davis did for me.
Ron Clark removed her and appointed me another counsel. But if you don't know the visas that you take to get to certain places, then in this litigation process you become lost.
Yeah. Like in my suit, like with you and Ron Clark, took Judge Guthrie off the case and appointed Roger Neal Moss to represent you. The same thing was done before yours was done in my case that Judge Davis, because I filed a motion to recuse her because she'd been having ex parte communications violating several congressional mandates upon her conduct without giving any kind of opinion to that, because if he gave an opinion, it could have caused the Fifth Circuit to remove her from the bench. And he didn't want to do that to her, but what he did do, he sui sponte removed her from my case, and then sui sponte appointed me Brad Siddell out of Potter Midnight Tyler to represent me. I didn't file no motion. He did that on his own.
Well, you know, a lot of times them district judges, they'll go up and above what you need. However, you really have to pin them in a box to get them on your side.
Well, it's based upon the merits of the claim. If they feel strongly that in your claim you stated something they feel has merit, and there's something you have a possibility can win, they're going to try to let justice run its course.
Sometimes. Because you can remember when Judge Guthrie dismissed our first 1983, right? We appealed to her boss, which was who? Ron Clark. What did he do?
They dismissed suit.
He dismissed it, so he followed her ruling, right? And what did we do? We didn't stop.
Well, I had discussed with you the law library that our game plan was to because there was critical key evidence that was never considered by Magistrate Guthrie or by Judge Ron Clark. That was very paramount to our claim, and so that was the game plan going before the Fifth Circuit, is to bring to the attention of the court there's been critical evidence that was not considered, and that to remand the case back for reconsideration of the evidence and then issue another ruling based off after they consider the evidence. But the Fifth Circuit went beyond that. They analyzed the evidence and basically said, it's competent summary judgment evidence, this case going to trial.
Going to trial, that's what they said, right? So that was a victory in itself.
It was a home run. In fact, you remember Mr. Enrique says, that's impossible, that can never happen.
Exactly.
And you served the order and said, no, tell me it can't happen, it just happened, there it is.
Hey, they always used to doubt me, right? And I used to tell them what?
That we ride with Jesus.
Ride with Jesus, because I'm his baby boy. I'm Daddy God's baby boy. And we've been blessed to overcome a few cases, right? Sent a few people home. One guy had a 40-year sentence where he had to do 40 years day for day. Remember old Joe? We got him down to where he come up for parole in 20 years. So God has blessed us with this.
Another point of the litigation, another guy, family members, I don't know how many actual inmates get to see the podcast that we're doing. I know that a lot of family members do. That one area of law that has really opened the door up is that goes beyond DNA. Mm-hmm. It's the state of forensic science. And a little history, in 2009, the National Academy of Science analyzed the state of forensic science here in the United States. And they issued, actually, it's a book called A Pathway Forward on forensic science. And they basically concluded that the only solid, reliable scientific evidence is nuclear DNA testing. You know, footprints, dental imprints, polygraphs, cell tower records, things of that nature are junk science. So what happens is the Texas legislature came along and acted what we call our junk science writ, called 11073 writ. It's done on the regular writ form, but it's called the 11073 writ, and what it does, it actually allows you to do something that was forbidden to do in habeas corpus, to go back and attack the sufficiency of the state evidence. And what it does, the statute basically says this, that if there was scientific evidence offered at your trial, and since the time of your trial, new science has come out that discredits that science, then you can utilize that writ, as in case in point under Robert Fisher's case. He had gotten his case reversed by the Court of Appeals, but the state filed PDR, and the Court of Appeals reversed it. Then they went on writ, and he had a lawyer, Mr. Mickelson, and they went on a writ, ineffective counsel, for and called an independent ballistic expert on his behalf, but the court ruled against him and dismissed his writ. Family lost all hope. Robert Fisher was in the choir with me on the Micah unit. They had lost all hope. They spent a lot of money for the counsel, and so I told Robert, I said, man, there may be hope for you. There's this thing called the 11073 writ. So we went back and I analyzed the facts and started drafting up pleadings before the Lord to review. And to come to find out, the cell tower records have been discredited up north, and on risks that they have actually had exonerated people on about cell tower records. Back in the day, they didn't have the GPS tracker. They went off the tires. Well, depending on the traffic, the location, you could be on your phone, and before you ping off, it could be a tire 350 miles away. So to say that somebody's in this area is junk science. And so Robert, we went off on a draft. I drafted the writ, sending it to Mr. Mickelson, and then he basically took my research and then he did the writ. And he didn't want to go with the cell tower records, but we went with it anyway because I told him we don't want to give the state away out. And we was able to secure an expert out of Boston, Massachusetts named Michael Cherry. He'd been successful up north on the cell tower records. And lo and behold, the Court of Appeals reversed his conviction. He had a 99-year sentence, and the case was finally disposed upon out of San Antonio A few months back, Robert went out and pled guilty to an 18-year sentence, and come October 2025, he was discharged. I think he went down for a little bit, and I think he just recently got out and made parole, and so it's fixed to come to an end. But that was 99 years. He was in a situation to where he would have to do 30 flat calendar years before he even come up for parole. And so he was able to the junk science writ. So anybody that has family members, if there was forensic evidence offered at your trial, look at that evidence and then research and determine, has that science that they use for your forensics, if it's been discredited, you can get a way back in under the junk science writ called Article 11073.
Now that's some wonderful information to know right now, because we are working on a case or two here and there. And people, we are not lawyers. Please, let's get this understood now. We are not lawyers. We cannot give you no legal advice. The only thing we can do is make suggestions and to show you what have helped us along the way in the field of litigation.
And when you go on your own
Don't
to your
get
library,
this twisted.
contact your lawyer and
Yeah.
we just try to steer you in the direction you need to go.
That you need to go to keep from getting blindsided by court-appointed lawyers, the court system as a whole, and the judges that you go before.
And another out group that does it, and probably the viewers and the readers are real familiar with it, kind of does the same thing, is the Prison Legal News.
Prison legal.
Started by Paul Wright. He started that publication.
Still
That's
in
where-
contact with
yeah,
them to this
and
day.
that's still in publication.
Yeah.
And that's what they do. They say what the case is ruling, what position the court's on. You have Kent Russell out of California, which periodically writes articles in there, and he gives you what they call his habeas hints to these traps and falls that you can fall into of the litigation. Because in Texas, it's called the one bite at the apple. You get one shot at it, and that's it.
They said throw everything in it but the kitchen sink.
Yeah, and so if it's
That's
not
what the
done
law
right,
says.
if you haven't done your research and marshaled your facts, you could waste your only opportunity to sit there and get your case reversed on a writ. And bear in mind, since the Harrington versus Richter and the Cullen versus Penholster cases in the U.S. Supreme Court used to, you had a lot of remedy under 2254, your federal writ. But when they decided those cases back in sometime, I think it's 2013, called Harrington versus Richter and Cullen versus Penholster, basically the Supreme Court has blocked the door to getting relief in federal court on state convictions. And so your main event is your Article 1107 writ. So when you get to that stage, guys, y'all got to make sure it's done right.
And that's something that cannot be rushed. A lot of time when we're in there, we want the quick way out, we want the faster way out, because we're missing family members, we're missing loved ones. Things that we never thought was important have become very important to us at this time. And we begin to rush the process of coming home. Well, when you rush the process of coming home, the first thing an inmate wants to do is file an ineffective assistance of counsel claim. Okay, but they never talk to the attorney about the ineffective assistance of counsel claim.
Or
They
get
never
family members
ask
to
him
make
for an
contact.
affidavit. They never ask the attorney for anything, right? So the first sign that the attorney get of this is he being ambushed by the prosecutor of the court saying that this inmate done filed ineffective assistance of counsel on you.
And let's also be real.